أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم نحمده ونصلي على رسوله الكريم. Uh, Nowadays we are discussing uh, will and testament under the major, or we can say that the main topic which we had started, I think, a couple of months back, leave a legacy. In that context, last Saturday, we had reached this point, and this is just the last slide, which I'll repeat in order to connect so that we have a perspective where we had left the discussion, and then we'll start today's discussion that is in continuity, but we are, Alhamdulillah, proceeding towards its conclusion. Last time we left it at this point. Taw'an wa karhan. For example, Quran says that when Allah subhanahu wa ta'ala created the systems in the universe, for example, solar system or sun, moon, earth, they all working together. So Allah subhanahu wa ta'ala said that I ordered them and I put them to work. I switched them on, and the word here, "ath," has been used, which has been literally translated and literally interpreted, that I asked them to come and they came willingly and unwillingly. This is the literal translation, which means that when they were put to function, ath, then when they were called to act, when they were called to function, when they were turned on, the system was turned on, it was put to work, the system responded, uh, the major features of the system responded, and the two major features of all those features were that they were working ta'an wa karhan, that they were working constrained and unconstrained. Although they were bound by the gravity, for example, they were bound by the gravitons, they were bound by interrelational bonding. There were so many other things by which they were connected, they were interconnected, yet they were working in such a way that each component was working as if without any constraint. The earth has been rotating, the sun has been rotating, the moon has been rotating since billions of years, and there is no uh, hurdle or any object or any obstruction to their performance of their duty or their motion or movement. So they are constrained, they are bound by the forces. Allah subhanahu wa ta'ala's fundamental forces are working on them, holding them together. They are working by Husbanin. They cannot overtake each other. It's not for the sun, it's not neither for the moon to take over. They are working according to the sunnah of Allah subhanahu wa ta'ala under the rules and under the law, and yet they are working in a manner that they are non-constrained. Now, this is paradoxical simultaneity, that there is a constraint and there is no constraint simultaneously. Or in other words, for example, in life, we find that there is a discontinuity. Person dies, or any living object dies. But in the cycle, and the last time I had given an example of, for example, of water, that in the cycle, this paradoxical simultaneity is working, and it is because of that there is continuity in the presence of water on the planet, and there is, although apparently the cycle shows as if there is discontinuity, that water is evaporating from the seas, water is melting on the glaciers, water is melting on the on the mountains, and it is flowing down into the river. It is changing states. So this is a paradoxical simultaneity of continuity and discontinuity, life and death. These two both are working paradoxically. خلق الموت والحياة ليبلوكم أيكم أحسن عملا. Without this cycle, there would have been no test. And then important concept which unfortunately some of our scholars, but particularly religious scholars, they have distorted it, that we are bound by the kismat, we are bound by the taqdeer, we can't do anything. Within the softwares which Allah subhanahu wa ta'ala has provided, and He has placed us within those softwares, we are free to act within those softwares. Nothing in the universe has nothing unlimited freedom. Even Allah subhanahu wa ta'ala says that I am on Sirat al Mustaqim. He uses the word Sirat al Mustaqim. I am on Sirat al Mustaqim. And he says that he has his sunnah, which means that he has his laws. He follows those laws. He works with those laws. So there is freedom within the determined software of that system. Otherwise, nothing from the atom or the subparticle to the entire singularity of the universe, there is no absolute freedom in terms of the existence. It is only Allah subhanahu wa ta'ala, last time we had discussed, who is eternal, who has absolute power, who is absolute authority, who has absolute freedom. Yet he says that I have put certain restrictions upon myself. For example, he says that I have enveloped everything in mercy. Mercy is enveloping everything. And he has prescribed sunnat for himself, and he is working within that sunnat, on that sunnat. So this is the paradoxical simultaneity which the scientists and the social scientists, they usually describe, and they have taken so many other factors which they describe, but here I have only identified three: continuity and discontinuity, constraint and non-constraint, and the determined and the free. It is simply, some people acknowledge it, but most of the people, they don't understand or they don't appreciate it. Historical legacies, now this is the historical part. We say that why Muslims are in this condition since last 1,000 years. Particularly from the 15th, 16th century. And that is also 1,000 years. Historical legacies are important components of many explanations of contemporary outcomes. This is the most neutral language. What are the contemporary outcomes? For example, Palestine has been occupied. This is the contemporary existing or the problem of the modern geopolitics. Although it is continuing since the last 100 years. They are fighting since the last 100 years, or more than 100 years even. But when we look at the history, we find that its roots, they are at least 1,000 years, they go back 1,000 years into the ground, into the history. In polities means into the entities, political entities, countries. I'm not using the word countries or nations because the nation and nationalism, these words are most modern. They have emerged in 20th century. Territory, country, these are modern words. Even rasat, it is a modern word. So I'm using a very, very neutral word, that the polities, entities of politics, for example, Medina, during the period of the Prophet, peace be upon him, was a polity. We cannot define it in today's terminology of Riyasat. Some people say Riyasat-e-Madina, but the word Riyasat or the concept of Riyasat or state or nation state, it was not there at that time. It is a product of 20th century. But we try to fix these things into the Riyasat-e-Madina, Islami Riyasat, and things like that. So these polities attempting to democratize. We are trying to democratize after the Second World War, after 1945, when the countries started becoming free. They gained independence because it was at that time, it was during that period that most of the countries who were colonized, they became independent. They gained freedom. It was at that time, after Second World War. Most of the countries, they gained independence after Second World War. They are still attempting to democratize. The authoritarian rule during the period of colonization was so deeply ingrained, founded into their legal systems, into their political systems, that still, even till today, they have not yet been able to come out properly. Took the example of Middle Eastern countries or many other South Asian countries. Only in a few cases, say in the Far East or some other countries, you will find that they have been able to democratize. But unfortunately, or fortunately for them, those countries who have been able to democratize with a higher degree, they are not Muslim countries. But the Muslim countries, they have very little to democratize. They are still ingrained into the colonial authoritarian system. Democratic failure at the root of disaster of polity. Again, I'm using the word polity and community, both polity and community, ummah and the polity. When we talk of ummah has no borders. Ummah has no borders. It is some borders. There are no borders. When we talk of state, riyasat, when we are talking of nation state, then it has geopolitical reference. It has geographical dimensions. It has political reference. It has some historical context. So these are the terms which we have to understand. Ummah has no borders. The state has a geopolitical reference, and community has a locus. For example, American Muslim community in America, Muslim community in UK. These are communities, Muslim communities, and they have a locus. They have a local reference. So we have to consider them, examine them in that context. Can be attributed to some legal legacy originating in prior authoritarian regime. The legacy which the British rule left in the Indian subcontinent. The legacy which French rule left in certain parts of India. They were not given independence in 1947 as the majority of states in India, Group A and B, they got independence in 1947, but the parts which were under French rule, they could not gain independence till 1964. They got the independence, for example, on the far eastern side, they got the independence after 1964. And there are many parts still under authoritarian rule in many parts of the world. Now I'm coming to the conclusive part of the entire discussion. We discussed philosophy under the topic leave a legacy, although we had started the discussion on the legal side, on the will and testament. So now we are returning to the discussion on will and testament. Now this part is mostly based on some of the questions which our colleagues at the MRC had raised, at the Mariam Islamic Center, MRC, they had raised some questions and they were still in my mind. So this is in fact in response to those questions. In civil law countries, for example, France is a civil law country. If some Muslims are living there, and Muslims are definitely living in those countries, for example, in Africa, There are many people in Houston who have come from civil law perspective, where France was ruling, and there are some many people who have come from those territories which were ruled by Britain. So they had common law system. So when they discuss will or testament, they are in fact discussing in the perspective of their own experience in those countries and the problems which they are facing in their law. At this point, I may point out that the will and testament, this I will clarify what it is. The will and testament, they are to be governed by the local jurisdiction. If somebody has a property in some country in East Africa or in Northern Africa or say in Indian subcontinent, in Pakistan or in India or in Egypt in the Middle East, they will be governed by the law which is applicable there. So when you are preparing a will, be very careful that where the property is located, and you have to prepare the will according to the requirements of the law of that jurisdiction. If you are in America, then you have to prepare a will under which is the requirement of the law of the land. Law of the land, not only generally speaking law of America, but law of the state. Texas law may be different from the law of New York, the law of Washington. It may be different. Therefore, you have to be careful. You have to find out that for which state, where your property is located, you are preparing a will or testament. In civil law countries, in these countries, whether civil law, Roman law, or the common law systems, even these words, legacy and legatee, they may have some different meaning, somewhat different meaning. So when these words are used in your document, be careful. Try to understand. Don't copy and paste the document from, for example, from Houston and paste it for your property in London. You have to use the same term which is used in London, not in Houston. Legacy and legatee. Who is legatee? Legatee is the person who receives the legacy, for example. These are different from American laws. This is what I wanted to point out. Roman law is not relevant to you now, so I'm switching over. And here, however, could also be instituted by testament. If there is no here, there is a difference, some difference. At some points, they are similar, but at many points, there's a difference in the laws of these countries and the laws of the Muslim countries. And what we call the Islamic law, there are differences. For example, in some cases where there is no hair, in these countries, there are different laws how to deal with this issue when there is no hair, whether the property will go to the estate or you can still have a hair. And his testament, the testator could charge his heir with legacies, that is, duties. You kindly remember, recall, I have been emphasizing right from day one we started the discussion that it is our misunderstanding that the inheritance passes to the heirs without any duty or responsibility. This is not the concept of Quran. And I had shown you the ayah. And under no law in the world, the inheritance does not pass without any responsibility or duty. It is a system of duties and responsibilities. It is enforceable at law. The law can take cognizance. The court can take notice of it. The court can punish it. There are civil penalties and there are criminal penalties. Be careful when you are dealing with the questions of will and testament and your heirship while dealing with these issues in these countries in the Western world. These are more civilized so far as the laws are concerned. then you might face a problem and might commit a crime if you don't understand the situation properly under the law. Because it carries certain duties to the third party. It is not the duty to oneself only that I have got this part, I have got this share, now I'm free. I have some duties to the third party. If I have got double the share of my sister, my daughter, I've got more than my daughter, I've got more than my mother, it means I have certain duties towards her, to the third party. This is the philosophy of the law of the Western world and law of Quran. I had pointed out. Wherever the quantum of share is mentioned, it is based on gender, zakara wal unsa, male and female. Wherever the actual distribution is discussed in the Quran, in the ayat, there it is based on relationship, and the relationships have responsibility. Well, walidain ihsana. If somebody is not doing ihsan with the walidain, he may become ineligible to inherit. He's getting double the share or more share than the female because of certain responsibilities. This is the entire basis crux of my discussions right from the beginning. Their duties to the third party, called the legatee, who has been mentioned in the legacy, who has been mentioned in the will, who has been mentioned in the testament as a beneficiary. The beneficiary must get the benefit of the property which has been assigned or which has been kept aside for that person. Kindly understand one more philosophy of the law, Islamic law or the Western law. This is such a law that it is the duty of the court to see that the testament should not fail. It is the duty of the court to see that the legacy should not fail. That is why the state is interfering. They have given them authority to take to the task the person who is violating the law. It is the responsibility of the legal system that the will should not fail, that the trust should not fail. But unfortunately, it is our misfortune that in the Muslim world, almost every or the overwhelming majority of the inheritance and the legacies or the wills or the wasiyat is failing. It is not working. The rights of the mother, daughter, sister, the weaker person, the orphan, they are being usurped, and there's nobody to protect them. It is the duty of the state to see that the will should not fail, to see that the trust should not fail. Called the legatee, this is a third party to whom the heir had to pay certain sums of money or had to give him some property or give certain assets of the estate. It has become the responsibility of the state to ensure that he gets or she gets her right. Otherwise, it is punishable here and hereafter. In French civil code, those people who have come from the colonies of France in Africa, for example, or even certain territories in India, Indian subcontinent. In French civil code and those countries that follow its pattern, however, the term here is limited to the universal intestate. This is a much finer description under law. I'm not going into that detail because it will take more time, but I think the crux is clear. Will or testament? What is the difference between will and testament? A will or testament is a legal document. As I said, when you write it, even in one word, there are certain wills in the world, reported in Guinness books also, in the legal documents also. There is one word will, two word will, 5-letter will. only 5 letters in a word, and that is a will. And there are certain longest wills also. Volumes of books have been prepared as will. Now, whether one word or a letter, once a will is declared, pronounced, or written, it is a legal matter. It is a legal document. And once it becomes legal, it is the responsibility of the legal system. And it is when it becomes a part of the legal system, then it is the responsibility of judiciary. And judiciary, you know, is the third pillar, one of the pillars of the state. Therefore, it is the responsibility of the state. And therefore, all other branches, all other pillars of the state, they will come to the aid of judiciary, the executive, the parliament. They will both help the judiciary to, so that the legal system, which is going to protect this legal document, maybe one word, a will or testament, that must succeed. This is so sacred a document. It is so important a document. After the failure of our family system in the Muslim world, this is the second most important factor. The failure of inheritance, which has failed our economy, which has failed our socio-economic system. And we are facing disgrace all over the world. These two, if we can place them and prioritize them, the family and the inheritance system. But there are hardly people who appreciate this. A will or testament is a legal document that expresses person's testator. Person who is writing the will or pronouncing the will, he is called testator. Testator wishes as to how his or her property. Now, the property which has been made the subject matter of will or testament, that is called estate. It is not the, in the general terms which we know that what the estate means, but here when we are referring to will or the testament, estate means the property which is the subject matter of the will, which the testator has willed. It is to be distributed after. This is very important. After. No legal system in the world, and the Quran particularly, the Sunnah particularly, does not allow anybody to claim the portion of his property that since I have inherit from my father or mother, I must get it before his death or her death. Nobody has the claim as long as that person is alive. The inheritance opens only and only after that moment of the death, when it is legally pronounced that man is dead, the person is dead. After his or her death. And as to who? Executor. Executor is the person who is mentioned in the will, that after my death, I am the testator. After my death, who will execute my will? Who will distribute this property? You remember we had discussed the word mawali in one of the ayat. We started the journey of discussion with that ayat, that mawali. But mawali, under Quranic designation, has more responsibilities than just the executor under the Western will. So anyway, who is the executor? And he has to manage the property till it is distributed. Sorry, till it is finally distributed. He has to manage the property. And Quran prescribes, don't go near the property of the orphans. The person who has died, now his children are orphans. His wife is a widow, or her husband is a widow. Don't go near that property, except in a proper manner, in a legal manner. Only with the intention and the responsibility to fulfill the desire or the wishes of the person who has died. And in managing the property, don't misappropriate it. However, one can take a salary, one can take the expenses which are involved in it, proper, appropriate, which are legal, which are commensurate with the job, not otherwise. We will look into that point also. A will historically applied only to real property. Now, this is the difference. A will applied in the past, will was, whenever a word, the term will was used, it was used for real property, real estate, real property. While testament, the word testament was applied to the personal property. Like you have a bank account, you have shares, that is categorized as personal property, although real property is also personal property. So you will see that with time, now these two terms have become the same, almost the same. And now there's no more discussion, but distinction. But in the documents, for example, your father may have prepared a will for you, or your grandfather may have prepared a will for you. In those documents, when they will be brought before the court will interpret the meaning of the will and the testament separately because they were written at that time. Under that law, they will have to maintain the distinction. Applied only to the personal property, thus giving rise to generally known title of the document as it was because of this distinction that the document was known as last will and testament. But nowadays, these two terms are used interchangeably. If you write only the last will, it's okay, it's sufficient. You write the last testament, it's okay. But you will find, for example, in the standard document which has been prepared in Texas about the will and testament, they use both the words. Thus, the word will validly applies to both personal and real property. Now they don't make the distinction. There was one question raised by one of our brothers here about testamentary trust. What is testamentary trust? A will may also create a testamentary trust. What is that? That is effective only after the death of the testator. You create a trust. You can create a trust. The trust may start operating in during your lifetime, but you can create a trust which may start working. It may become effective only after death. Now, this is different from something else, which is transfer on death deed. That is different. That is not a trust. Transfer on death, a deed is prepared for that, which is called deed for the transfer on death. That is not a trust. That is something different. Here, it is a trust. The testamentary trust, which is called testamentary because this trust is created by the testament, by the will. A trust created by the will becomes effective only after the death of the testator, the person who is making a will. A trust is a legal relationship. Now creating a legal relationship with the person. Maybe he is not related to you otherwise, but with this, under this trust, when you are putting a trust in him and you are making him a trustee, now that creates a legal relationship. It can be with a person who is already related to you, a blood relation or any other relation, or who is not related to you at all. But you are creating a legal relationship. And he is bound. Once he accepts it, he is bound. A trust is a legal relationship registered as deed. Registered. Note this. It is to be registered as a deed in which owner of property, which is transferring a right, here only ownership of the property is not sufficient. It's a legal thing which is mentioned in the brackets. Transferable right. You may be owner of something, but you may not be able to transfer the right. You may own a property, but you may not have the title. If you don't have the title, it's not a transferable right. So be careful of these things also. You are an owner, and at the same time, you have the right to transfer. It is a transferable right. It gives to another to manage the person to whom this is being given, the trustee. He is being given a new role in the legal relationship, a new role to manage and use this property. He can use it. He can sell it even under the terms of the trust. He can utilize it not for himself, for the benefit solely, only for the benefit of a designated person, the person who has been designated as beneficiary in the document. Only and only for him, solely for him, he can manage it. He can manage it. He can use it, but not for his benefit. In English common law, for example, those colonies which were British colonies, the party who enters property is known as settler. Now, in the will or the testament which we created, when I'm making a wasiyah there, I was a testator. But in the case of the trust, when we are creating a trust, as I said, that you have to be careful what terminology is used by that jurisdiction. For example, your property is located in London. So therefore, when you are creating a testamentary trust or a will trust, there you will use the language for the trust. I'm talking about the trust. In the trust document, in the deed, you will use the language, and there you will not say testator, but you will say settler. It's a settler with O. SETTLOR, settler. The party to whom it is entrusted is called the trustee. The person who is going to manage, he's called the trustee. The party for whose benefit the property is entrusted is known as beneficiary. I have mentioned that. And the entrusted property is known as corpus. The entrusted property to the executor in the will and the testament, the property which was being distributed in the will or in the testament, that was known as estate. I had shown you that was known as estate. But here, when you are making a testamentary trust, creating a trust, here that property will be known as corpus or the trust property. Corpus or the trust property. I think I leave it here. Next time, inshallah, Allah willing, we will start from here. And if there are any questions, we will discuss that also. Subhana rabbika rabbil izzat amma yasifun wa salamun ala al-mursaleen walhamdulillahi rabbil alameen.
اللهم صل وسلم وبارك على سيدنا محمد وعلى آله وصحبه. اللهم اهدنا فيمن هديت وعافنا فيمن عافيت وتولنا فيمن توليت وبارك اللهم لنا فيما أعطيت وقنا واصرف عنا شر ما قضيت فإنك يا ربنا تقضي بالحق ولا يقضى عليك. اللهم ادخلنا برحمتك في عبادك الصالحين. اللهم اخرجنا من ظلمات الجهل والوهم إلى نور العلم. اللهم علمنا ما ينفعنا وانفعنا بما علمتنا وزدنا علما. اللهم اجعلنا ممن يستمعون القول فيتبعون أحسنه. اللهم اكفنا بحلالك عن حرامك وبطاعتك عن معصيتك وبفضلك عمن سواك. اللهم بفضلك ورحمتك أعلي كلمة الحق والدين. اللهم انصر الإسلام وعز المسلمين يا أكرم الأكرمين. Oh Allah, spread your mercy upon us. Shower us with your blessings. Increase our knowledge, grant us forgiveness, and reward us with the company of the prophets in the Firdaus al-A'la. Oh Allah, purify our hearts, strengthen our faith, increase our knowledge, and make us benefit from what you have taught us. Oh Allah, forgive our parents and all our friends and relatives who have passed away. Oh Allah, make their graves garden from heaven and grant them the Firdaus al-A'la. Oh Allah, we have many of our friends and relatives who are sick. Oh Allah, grant to all of them full and speedy recovery. Oh Allah, guide our children, protect them, and make them righteous. O Allah, grant us the power and the ability that we may be grateful for the favors you have bestowed upon us and our parent, and that we may do righteous deeds that are pleasing to you. O Allah, we seek from you all of the good, whether we know it or we don't. And we seek your refuge from all evil, whether we know it or we don't. O Allah, we seek refuge in you from incapacity, from laziness, from fear, from greed, from poverty, and from the torment of the grave. O Allah, we have many of our brethren who are living under oppression and injustice. O Allah, heal their trauma, protect their helpless, and grant them lasting peace and prosperities. O Allah, we ask with every name you have elected for yourself, that none of us leave this gathering, but his pains have been relieved, his worries have been removed, his debts have been paid, his weaknesses have been concealed, his sins have been forgiven, and his needs have been fulfilled. سبحان الله وبحمده عدد خلقه ورضا نفسه وزنة عرشه ومداد كلماته. سبحان الله وبحمده عدد خلقه ورضا نفسه وزنة عرشه ومداد كلماته. سبحان الله وبحمده عدد خلقه ورضا نفسه وزنة عرشه ومداد كلماته. والعصر إن الإنسان لفي خسر إلا الذين آمنوا وعملوا الصالحات وتواصوا بالحق وتواصوا بالصبر. وآخر دعوانا أن الحمد لله رب العالمين والصلاة والسلام على خير المرسلين. اللهم صل وسلم وبارك على سيدنا محمد وعلى آله وصحبه والسلام عليكم ورحمة الله وبركاته.